Howdy, folks. My name is Gabriel Harber, and I don't know my grandfather-in-law very well at all, just being honest. In fact, I think it actually helps for purposes of sharing this story with you that I'm not very close to him, because at times what I'm about to share with you is a bit unbelievable. But I promise, if you stick with me, if you listen to this story until the very end, at the very least you're going to learn something. And my prediction is that you'll become just as passionate about this issue as I am, because one of the things I've learned about this issue is that it's not just my grandfather and our family that's been affected. There are thousands of families that have been affected by this unconstitutional, completely asinine law on the books in Pennsylvania and similar laws on the books in many other states that leave a person with no options and no due process. I've cataloged all of the legal documents that we'll be discussing and going over on Dropbox. There's a public link available at corruptclearfield.com. If you have any questions about those documents, you have any questions about anything else, please feel free to reach out to me at fearthebeardmedia@gmail.com, or you can hit me up on Twitter. My name is @crazygaby. Again, that's fearthebeardmedia@gmail.com or @crazygaby on Twitter. I would absolutely love to talk with you folks, explain anything you might have any questions about. Now, before we dive into my grandfather's story, I want to go ahead and lay the groundwork for all this, the framework. And to do that, we need to define our terms. So, in the interest of fairness, I've sought out what I believe to be one of the more neutral sources on this issue, or at least a source that begrudgingly was forced to tell the truth. That'll make sense in just a moment here. Got a Huffington Post article by family and matrimonial lawyer Liz Mandarano. She's a blogger for Huffington Post, and it is about protection from abuse orders, restraining orders. They're called PFAs, protection from abuse in Pennsylvania and some other states, but the term restraining order is generally interchangeable. PFAs usually are specific to family members or friends or anyone connected to those people. A little bit more of an intimate law. Anyways, got a couple of excerpts here I'd like to read from her article, and I should also, I guess, point out that Liz is a self-ascribed feminist, is somebody who, of course, the idea and the concept of restraining orders are very important to. Protecting women, women's rights, something that is very near and dear to her hearts, and frankly, something we all care about. Started off with this. Orders of protection are critical to the safety of many. Some people claim that they are simply pieces of paper that mean nothing. Detractors point to the horrible stories where people are abused or murdered despite having an order in place. However, it is also an unfortunate truth that because they are incredibly easy to obtain, orders of protection are often misused, especially against men, and this false practice clogs the system unnecessarily, preventing true victims from having their cases thoroughly examined and depleting victim assistance resources. There are between 2 and 3 million temporary restraining orders issued in the United States annually. Despite their huge impact on a person's emotional and financial well-being, in order to receive a temporary stay-away order of protection, one needs only to allege that he or she feels threatened by their partner. There does not need to be any history of domestic violence whatsoever. There does not even have to be an actual verbal threat of domestic violence either. Likewise, there does not need to be evidence of a major overt act such as stalking or purchasing of a weapon. These orders are issued ex parte, which means the accused has no notice of the proceeding and does not have the opportunity to defend himself prior to its issuance. The burden of proof for PFAs is the lowest legal standard available by a preponderance of the evidence, which basically means that a judge has to believe that there is a 51% chance, i.e. more likely than not, that the allegations are true. These orders are granted with barely any accountability as to the facts alleged, although they often include a stay-away provision for minor children. A temporary order of protection lasts until you have the opportunity for a full court hearing, which unfortunately does not necessarily get scheduled for up to 6 weeks sometimes, and due to clogged judicial systems, sometimes a full hearing can take months. Nor does the hearing necessarily occur at the first court date. Adjournments from both sides trying to gather evidence for and against the order are common. Notably, there is no right to discovery prior to the hearing, and once a hearing takes place, the burden of proof remains the same low standard, that 51% chance referenced above. It is a well-known fact within the matrimonial legal community that many lawyers and their clients use these orders of protection to gain a strategic advantage over their spouse from which it is difficult to recover. And since no judge wants to be the one who, quote, gets it wrong, leading to a tragic result, these orders are easily obtained. It often serves as a bargaining chip. Many men are forced to agree to a permanent order of protection either of the same or more limited scope in return for something else, such as lower spousal support or more access to children. It drains resources as well. It gives the accuser the upper hand in property litigation and spousal support. The ousted spouse has no access to their financial documents, tax forms, personal property, safe deposits, deeds, etc. It also emotionally puts people on the defensive. They have no access to their their belongings or their family. The innocent who are accused are therefore thrown into overwhelming turmoil from which it is difficult to recover. Sadly, it creates a windfall for the attorneys. Once a stay-away order is issued, the parties cannot communicate with each other. All communications must therefore be carried out via the parties' lawyers. As a result, there is a strong incentive for the less ethically minded lawyer to protract a legal battle by encouraging this tactic. There has been a small effort to address the problem, but none have made significant efforts to remedy it. In New Jersey, in 2008, one trial judge found that the current standard of proof was unconstitutional in that it violated the defendant's rights to due process and required the stricter, clear and convincing evidence standard. However, the appellate division overturned the ruling. That ruling was later upheld by the New Jersey Supreme Court. A few recent studies examined this problem. One study found that 59% of allegations against domestic violence between couples involved in custody disputes could not be substantiated by the courts as true. A 2008 analysis of orders issued in one county in West Virginia concluded that 81% were unnecessary or false. A 2010 review by Connecticut's Judicial Department noted that ex parte orders increased over 25% from 2003 to 2004, but nothing was done to stop these frivolous requests. There's pretty much no doubting my feminist camp allegiance, says Liz, and it was a personal challenge to review many anger-driven websites and read commentaries blasting women while still writing this article and acknowledging that there is a systemic-wide problem. Well, I hope you're still with me after all of that, and I hope your blood is boiling, just like mine is every time I read that. You see, Liz is a lawyer. Liz is also a noted self-ascribed feminist, and Liz herself is able to see, as I believe you probably are now, and I know I am, that these orders are not only unconstitutional, these orders end up ruining the lives of good, honest people. Now, yes, of course, they do save lives. Of course, they do help women who are in need. No one will deny that. But the question must be asked. If a law is put in place to protect a certain class of people, those who have been victims of some sort of domestic dispute or violence, but in saving those people or in helping those people, you create an entirely new victimized class, arguably even more downtrodden than the one you were trying to save, at least in terms of numbers and options available, what have you really done? What have you really accomplished? These PFA, protection from abuse orders, are something that must be addressed in the court systems. Now, if you'd allow me, and you have to, I guess, since this is my podcast, I'm going to read you a couple more stats, and then we're going to get into my grandfather-in-law's story. Spoiler alert, it might just be about protection from abuse orders in Pennsylvania. Pennsylvania's Protection from Abuse Act was hailed nationwide when it was enacted as a progressive law providing crucial protections for victims of domestic violence. It enabled courts to issue emergency no-contact orders at a time when filing criminal charges was the only legal recourse for victims of abuse. It also featured a provision that remains controversial to this day. Courts could temporarily evict defendants from their homes based solely on a plaintiff's accusations of abuse. Detractors warned that the PFA law itself would become subject to heavy abuse. The lone nay vote against the PFA law was Senator William Duffield. He says, "I do not think that there is much of a need for it. It would open up a Pandora's box to every family squabble." Also important to note, according to official statistics, 1 in 3 women will experience some sort of domestic violence in their life, but surprisingly enough, 1 in 4 men will also experience some sort of domestic violence in their lives. Now, that's not to diminish one group or the other, simply to paint a picture that any law targeting one group specifically or abused by one side specifically is a law that must be examined and brought under heavy scrutiny. I continue with some facts here. Family law judges, attorneys, and advocates still grapple with whether PFA law strikes the right balance to protect victims while also limiting false claims of abuse. People frequently misuse PFAs to harass, to get someone evicted, or to gain leverage in a divorce or a child custody case. Want somebody out of the house? File a bogus PFA, the Allegheny County Court of Common Pleas Judge Kim D. Eaton told one researcher. The PFA system is often derided as a poor man's custody, Judge Eaton says, because it allows people to obtain child custody orders while circumventing the formal custody process and associated court fees. There is no fee for filing a PFA, and nearly all PFAs are granted at least on a temporary basis because courts prefer to err on the side of protecting domestic violence victims, which is not a bad thing. In fact, that's a very good thing. It's only a bad thing if the way they go about protecting domestic violence victims is unconstitutional and leaves those victims with no recourse to defend themselves in the face of false allegations. In 2011, judges in Allegheny County approved 97% of all initial PFA petitions. And in about 60% of those cases, the plaintiff either withdrew the petition or failed to appear at the evidentiary hearing 10 days later. Over time, amendments to the PFA law increased the maximum duration to 3 years, expanded the definition of abuse to include stalking and harassment, and implemented a statewide database of all PFA proceedings operated by state police. The PFA law does state that a person who files a PFA in bad faith must pay the defendant's attorney fees and can be criminally prosecuted, though this almost never happens. Proving bad faith is impossible in most cases because of the he said, she said nature of domestic violence. PFA plaintiffs are entitled to free attorneys who help file the petition and represent them at the hearing, but more than 2/3 of PFA defendants receive no legal representation because they cannot afford an attorney, do not appreciate the severe consequences of a PFA, and also because public defenders are not available for defendants of PFA allegations. A PFA is a public record that can haunt people like a criminal conviction. It can spoil job prospects for teachers, police officers, daycare workers, and others subject to background checks and abuse clearances. It can impede a person's constitutional right to own guns. And though it is only a civil order, violating any provision of a PFA can result in a 6-month jail sentence and a $1,000 fine. As I hope I've laid the case out for, PFAs are at best a misguided effort to protect domestic violence victims. And at worst, they're creating an entirely new class of victims with even less rights than the victims they sought to protect in the first place. Unfortunately, this is the way laws are often made in this country. Legislation is passed, we try to fix a problem, and we end up creating new problems that are even worse in the process. Now, I appreciate you sticking with me as we laid out that groundwork. We're going to dig into my grandfather-in-law's story. For the rest of this podcast, for the next few minutes, I'm going to introduce you to all of the major players in this story, so you'll have an idea of who each of them are, and I won't throw you in cold when I bring one of them up. If you have any questions about any of these folks, you can use the same contact information I listed at the beginning of this podcast, or you can just refer back to this podcast, episode 1, and listen to this part all over again. A few words before I introduce the characters. This entire investigation has come at a great personal cost, not only to myself and my family, but of course to my grandfather-in-law, John, his children, his friends, the church he was a minister over, congregation. A great personal cost that he has had absolutely no remedy from a legal standpoint to fight back against. It's not only financial, it's also in relationships that have been strained, reputations that have been tarnished, and opportunities that will simply never be available again. I only ask that as you listen to all of this, you keep my family in mind, on your thoughts, in your prayers, and we appreciate you taking the time to listen to this story. I feel fortunate that I understand how to operate this medium, how to put this out, and I sincerely hope that even if my grandfather's case is a lost cause, even if it's unable to be altered, I hope that this will be enough to raise awareness and to provoke some of you into action so that these unconstitutional policies can be challenged and struck down, preventing future thousands of families from being fractured and men's lives from being ruined. Let's start with Tara Hoover Gill. Tara was the wife of my grandfather. She's almost 30 years younger than him, which should probably raise a red flag or two for most thinking folks. And this is the 5th man that she has actually done this to. Not all of them were her husbands. This is the 5th person she's drained, slapped a multitude of PFA charges and violations against them, and then left them high and dry while taking as much in terms of financial and physical resources from them as she could. She claims, and continues to this day to claim, that she has worked for many top-level government agencies such as the FBI, the NSA, and the CIA, and that while working at these agencies, she had high-level security clearance. Pretty much every person that came in contact with Tara was told these things, and it was really no secret, though we all had our suspicions. Some, I'm raising my hand, far more than others. I wrote it off as harmless at the time, and I wish when I first met her and first heard her say these things that I would have been more alarmed, more driven to actually dive deep into who she was, maybe even prevent all of this from happening. Tara has also worked for the Clearfield County government on a few different levels, most notably in the district attorney's office for some time. That'll make sense in just a moment. She also worked for the private law firm as a legal secretary, Mikesell and Mikesell. Again, that'll make sense in just a moment here. Moving along to John Gill, my grandfather-in-law. He was married to Martha Gill for over 40 years. That would have been my grandmother-in-law had she been alive when I married my wife. He's been a minister for over 50 years, much of that as as the head of the Believers Tabernacle Church in Hyde, which is a small township right outside of Clearfield. He has no prior criminal record, which is quite staggering considering all of the information you're going to be taking in over the course of this podcast. Next up, we have Judge Paul Cherry. He's currently serving his second 10-year term as a judge in Clearfield County, this term running until the year 2023. He's known as a strict disciplinarian, and he was the Clearfield County District Attorney for more than 9 years and a public defender for Clearfield County for 6 years before that. Judge Frederick Ammerman is the president judge, Clearfield County currently. He was a Clearfield judge since has been a Clearfield judge since 1994, and was the district attorney for Clearfield from 1988 to 1994. If you haven't already started to get the picture, there's a lot of close proximity between all of these folks. The current district attorney, Bill Shaw, became the DA in 2004 when Judge Cherry began his first term as a judge in Clearfield County. He was the judicial law clerk for Judge Frederick Ammerman, the guy we just mentioned before that. He also just so happens to be friends on Facebook with Tara Hoover Gill. Assistant District Attorney Warren Mikesell, surprise, surprise, worked at Mikesell and Mikesell, private legal firm, which Tara Gill just so happened to be legal secretary at for a time. He's worked in Clearfield since 2006 as the Assistant District Attorney, and he also had previously served as an Assistant District Attorney under Judge Ammerman from 1992 to 1994, and under Judge Cherry from 2003 to 2004. New kid on the block, Assistant District Attorney Ben Baker, has only been in the office since August of 2015. There's not a lot to say about him yet, but trust me, he's going to matter a little bit later. Stephanie Cooper, private attorney, is John Gill's previous attorney, and somebody that we'll talk about quite a bit as this podcast goes on. For now, the most interesting piece of information, though, is that she ran for judge in Centre County in 2011. Centre County being a county adjacent to Clearfield County. If any of you know where State College is, where Penn State University is located, that would be Centre County. Not a factual piece of information here, but one that is corroborated by pretty much everyone I've talked to within the legal system. If you want to be a judge someday, you gotta pay your dues, butter up the right people, and all in all, play by the rules so that you can gain the favor of others who happen to already be judges and gain the influence needed to win that seat. Very prestigious to become a judge. Very difficult as well. Lastly, a couple of folks who are not in the legal system but are of significance to this story. Billy Jack, the assistant minister, assistant pastor, whatever terminology you would prefer to use, and also the best friend of John Gill, my grandfather, since approximately 2012. He met John by chance approximately 1 year after he and Tara were married, became the associate pastor, assistant pastor, again, whatever title you'd like to use. Second in command is probably the best way to refer to him. He was written into John's will for the church and the house, claims he used to work for the FBI, and strangely enough, Billy Jack is not his real name. It's an alias. His real name is James McPherson. Last character I'd like to introduce to all of you is Hope Martin, a member of John's congregation previously and no longer after an event that took place, which we will discuss in a future episode. She's pretty much an innocent bystander of all of this, but because of her close proximity to all of the different characters, all the different players, her story and her interview was particularly significant. Tara moved in with her after she left John, and she was also a member of the Phillipsburg Latter-day Saints Church, which is going to have a significant role as we move forward. Thanks for listening to this episode of Corrupt Clearfield. Remember, you can follow along with all of the documents I'm referencing at corruptclearfield.com. Just scroll down and click the link to the Dropbox file. All the documents are cataloged in order as they appear in each episode. You can also help to support this investigation as it continues, and also our family as we attempt to recover from the damage that has been done. You can donate either by going to corruptclearfield.com and clicking the link as you scroll down the page, or you can go directly to paypal.me/crazygaby. That's my broadcasting alias. Again, that's paypal.me/CRAZ as in zebra, YGAB as in Bravo, EY. Thanks for listening. Until next episode.